In 1386, in the Norman town of Falaise, France, a convicted murderer was dressed in human clothes, led to the public square, and hanged. The execution cost the exact same amount as any other, requiring a judge, armed guards, and a professional executioner. The only difference was the defendant, a pig. The Falaise hanging was a formal legal procedure. We have the town receipts, the official court transcripts, and the contemporary sketches showing sows standing in the defendant's box before robed magistrates. Between the 13th and 19th centuries, courts across Europe tried an entire zoo of offenders. Cows, horses, and dogs faced criminal magistrates in France, Germany, and Italy. In Switzerland, a judge assigned legal representation to a swarm of Spanish flies. In another case, a pregnant mole was given a brief judicial reprieve to vacate the premises. Exterminating pests or slaughtering a dangerous animal is cheap and easy. Paying court clerks to record witness testimony against farm animals requires a society to expend vast resources on legal theater. To understand why a town would waste time and money hiring a lawyer for a mole, we have to look at the rigid logic of medieval law. This infographic maps out how medieval courts separated these cases. The justice system split animal offenders into two rigid jurisdictions, based entirely on their relationship to humans. The secular courts handled domesticated animals, creatures like pigs and mules that lived directly under human control. If a cow trampled a farmer, it faced an individual criminal trial. A guilty verdict almost always ended with a physical execution, carried out in the same public squares where human criminals met their end. The ecclesiastical or church courts took the cases involving wild pests. Because swarms of rats, locusts, and weevils operated outside human control, they fell under God's jurisdiction. These trials addressed community-wide devastation, like famines, and ended with spiritual punishments, like a formal excommunication by a local bishop. Judges applied meticulous logic to these categories. They did not drag animals into the street for random acts of mob vengeance. They processed them through a strict legal bureaucracy that mirrored the medieval understanding of the natural world. This commitment to due process is documented in an early 16th century case involving the rats of Autun. The court appointed a young lawyer named Bartolomé Chassanet to defend the local rodent population against charges of crop destruction. When his clients failed to appear in court, Chassanet requested a delay. He argued that a court summons implies safe conduct to the trial, but his clients were terrified of the village cats and would risk death if they attempted the journey to the courthouse. The judge accepted the argument and granted the delay. Laughing the defense out of the room or ignoring the rules of procedure would have compromised the integrity of the entire legal apparatus. The rats were entitled to a fair hearing. Affording a rat the full protection of the law proved to the community that human reason still governed the universe. The precise execution of the rules mattered far more than the physical presence of the defendants. This still leaves a massive theological dilemma, debated heavily by scholars like Thomas Aquinas. If animals are irrational, putting them on trial is entirely futile. But if they act as agents of God's will, placing a curse on a swarm of locusts borders on blasphemy. To resolve this, legal scholars looked to the concept of cosmic equilibrium. As ancient literature professor Jacob Finkelstein argued, medieval society believed animals occupied a specific lower level in the hierarchy of creation. When a pig killed a human child, that animal breached the natural hierarchy. The visible evidence of that breach had to be removed through a highly solemn public procedure to demonstrate that the cosmological equilibrium had been restored. The guilty verdict served as a mandatory ritual. Executing an animal was never about proving moral guilt. It was a mechanism to repair a tear in the fabric of the universe. The pig hanging from the gallows didn't understand the sentence, and the rats hiding from the village cats never knew they had a lawyer. The entire spectacle was engineered exclusively for the traumatized humans watching the proceedings. When an infant is killed by livestock or a season's harvest is wiped out by pests, a community experiences a profound crisis. The legal process functioned as a social drama, giving devastated towns a structured way to confront meaningless tragedy. We can visualize this psychological mechanism as an act of domesticating chaos. The unpredictable, terrifying expanses of the natural world are squeezed into the perfectly rigid, symmetrical grid of human law. By issuing a subpoena to a locust, a judge transforms a random act of God into a solvable crime. The trial imposes strict rules on a disaster, allowing the community to reassert cognitive control over their deepest fears. Eventually, a glaring legal paradox brought the trials to an end. Holding an animal legally accountable for its actions logically implies that the animal possesses a basic level of legal rights. A society cannot easily afford a pig a defense attorney and a fair trial on Tuesday, and then slaughter its siblings for breakfast on Wednesday. The tension between prosecuting animals and consuming them became impossible to maintain. Dragging a cow into a courtroom looks like a bizarre relic of the past, but it reveals exactly how far humans will go to feel safe. When faced with a chaotic and indifferent universe, we will spend any amount of time, money, and effort required to manufacture a sense of justice and order.